Please be seated. We're in your ready, counsel?
Yes, Your Honor.
Yes, Your Honor. We are on the record in the Iowa District Court for Jefferson County, case FECR 005143, State of Iowa versus Willard, Noble, Jaden Miller. The matter before the court today is a motion to suppress filed by the defendant. It's also a pre-trial conference set for today. Present for hearing today is Assistant Iowa Attorney General John Brown. On behalf of the state, Jefferson County Attorney Chauncey Molding on behalf of the state. On behalf of the defendant who is personally present, Nathan Olson and Christine Branstead. Counsel, anything that we need to take care of before we get started with either the evidence or the argument of counsel?
I don't believe so, Your Honor.
No, Your Honor.
Okay, I'm going to have counsel start with the motion to suppress. Is it Mr. Olson? Okay, go ahead.
Thank you, Your Honor. May it please the court, counsel. We're here today on the second motion to suppress filed on behalf of Mr. Miller, asserting both his constitutional rights under the United States Constitution and the Iowa Constitution. He is also asserting certain rights of co-defendant Jeremy Goodale through Iowa Rule of Criminal Procedure 2.12. We've outlined that extensively in our motion and briefing, but just as a brief outline, those are the rights that we're here to discuss today. Part of the reason that we're here in the second motion to suppress is, as the court's aware, Mr. Goodale, until recently, was listed only as a co-defendant. He has now been listed as a witness for the state, and in order to ensure that all constitutional rights are protected and that all constitutional rules are followed in the collection of evidence, Mr. Miller has to assert the rights and provide this court description of the violations that occurred regarding both him and Mr. Goodale. That provides good cause for this court to hear these issues before it this morning. There's 6 issues presented. The first is suppression of statements made by Mr. Miller while he was in custody. Mr. Miller was arrested. I don't think that there's any question that he was taken into custody by law enforcement on November 4th of 2021. He was taken to the law enforcement center. He was put in a locked room. He was held. And there was no arrest warrant. The record makes clear. This court has heard testimony previously and has seen deposition testimony and other exhibits previously. He was arrested. There wasn't an arrest warrant. Therefore, his constitutional rights were violated by holding him in custody and extracting statements from him while in custody. Those are not considered voluntary, and any statements made by Mr. Miller should be suppressed because he wasn't validly and constitutionally arrested. Instead, he was just taken into custody. There was, as this court is aware, a warrant for the taking of DNA evidence and fingernail scraping evidence. However, taking Mr. Miller into custody and holding him for multiple hours in custody to extract that evidence was an unconstitutionally broad and an overreach of any authority that that warrant provided. Here's why. When Mr. Miller was first confronted with law enforcement at his home in the early morning hours of November 4th, there were evidence collection technicians there on the scene. They were there. There is nothing about extracting DNA through a buccal swab of a cheek, and nothing about a fingernail scraping that had to be done at the law enforcement center. In fact, the technicians to do that were at the scene and could have done it right there. We heard testimony, and there's evidence before this court in the prior suppression hearing and through the exhibits this court has. So therefore, the taking of Mr. Miller into custody and arresting him at that point was overly broad. And since it was overly broad, the warrant to get the buccal swab for DNA and the fingernail scraping cannot support the in-custody holding of Mr. Miller. So that warrant cannot support it. So therefore, those statements still get suppressed, even if this court finds that that warrant initially could have allowed Mr. Miller to be very briefly taken into custody. Further, Your Honor, that warrant actually was invalid. And as we pointed out in our briefing, there's different warrants for different things that law enforcement wants to do. They can arrest someone with a warrant, take them into custody. They can look for evidence using a warrant, a search warrant. I want to look at this place for this thing. Or they can get a warrant for collection of non-testimonial evidence. And that's Iowa Code Chapter 810. To get a warrant for non-testimonial evidence, such as DNA evidence and fingernail scrapings, not statements, but just physical evidence, certain things must be done. There's certain checkboxes that law enforcement has to fill in for a magistrate to issue that non-testimonial evidence search warrant. What's important in this case is that the Chapter 810 warrant wasn't used to request the DNA evidence and the fingernail evidence. All those requirements were not met in the actual search warrant application that was requested for the non-testimonial DNA evidence and fingernail scraping evidence. And because that wasn't performed, that warrant is actually invalid. This court is well aware of the rules of statutory construction. If there's a search warrant, if the Iowa legislature says, law enforcement, if you want DNA evidence, if you want to get that fingernail scraping, you have to use this particular form, legislature controls. They told law enforcement that they should use Chapter 810 if they want DNA evidence. In this case, law enforcement didn't use Chapter 810, and they didn't conform with the requirements listed in Chapter 810. And because they didn't conform with that, any search warrant for that DNA evidence and buccal swab evidence was invalid, and any seizure made underneath that warrant was unconstitutional. So again, law enforcement here in the state can't stand on any argument that the seizure made of Mr. Miller was to collect DNA evidence and fingernail scraping evidence. And we also know, and Iowa law is very clear, that's the Bozeman case we cited in our brief, B-O-U-S-M-A-N, 630 Northwest 2nd, 789. The pin site's 800. I mean, that's an Iowa Supreme Court 2001 case. Law enforcement doesn't get any flexibility or leeway when it comes to this non-testimonial evidence. If they don't check one of the boxes that is required under Chapter 810, the search warrant's kicked out. And anything taken gets kicked out as well. So what does that leave us with? That leaves us with a seizure of Mr. Miller without an arrest warrant, a seizure of Mr. Miller without any warrant at all to take any physical evidence from him. He was held for multiple hours. He made statements in custody, and those should be suppressed. because he was held against his will by law enforcement. And any holding, even if this court does determine that that warrant was valid, the holding of Mr. Miller for hours and hours, when that brief seizure actually at the scene to take a cheek swab and collect fingernail scraping evidence, could have been done by the techs at that scene. That's where it should have been done, and any seizure above and beyond that was far beyond any scope that could be allowable under that search warrant application. That's our first issue, Your Honor. Our second issue, suppression of Mr. Miller's in custody statements under Chapter 232, specifically 232.11. But we were before this court previously discussing the actual interrogation of Mr. Miller, and we discussed Chapter 232.11 regarding the interrogation. Chapter 232, or Section 232.11, has two separate and distinct requirements for counsel for a juvenile. The first is when they're taken into custody, and the second is during interrogation. We're here talking about that in custody, the taking of in custody, because if you read the section and if you read case law, it does provide two separate and distinct requirements for counsel of a juvenile. Why is this important? Because, Your Honor, you previously said, well, there's a forcible felony here at play, and your ruling provided that because there's a forcible felony and because we're here in adult court, the juvenile rule doesn't apply. That was your prior ruling, Your Honor. However, the case law that we've cited also makes clear that conspiracy is not a forcible felony. Therefore, Mr. Miller, regarding the charge of conspiracy, is still considered a juvenile under Iowa law and is still entitled to every single protection under the juvenile code that juvenile individuals who are accused of offenses is provided. Because on the conspiracy charge, he was not afforded an attorney as soon as he was taken into custody, and he was not provided any of the rights under Iowa Code Chapter 232, or specifically Section 232.11, any and all statements made should be suppressed under Section 232.11 and the conforming case law. Again, we've cited that in our brief. But in this instance here, this court is to look at those charges separately, and suppression of all statements is necessary for the conspiracy charge. Those may not be used against Mr. Miller when viewing the conspiracy charge, even though we're in adult court, because he is still considered a juvenile in the eyes of Iowa law. The third issue before this court, Your Honor, is an assertion of a number of statutory, the third issue is an assertion of rights for Mr. Goodale. We're here under Iowa Rule Criminal Procedure 2.12. We've outlined it in our brief, but that rule specifically provides that an individual who is aggrieved by an unconstitutional search or seizure may assert a suppression claim. A person who is aggrieved. We're here under that operative language, Your Honor. Because Mr. Miller is aggrieved by the unconstitutional searches and seizures that were made against Jeremy Goodale as well. He is aggrieved because he is charged with conspiracy, as is Mr. Goodale. This court is well aware. When a charge of conspiracy is at play, statements made by co-defendants, co-conspirators, individuals that the state says were part of a conspiracy, may be entered as evidence against a defendant, regardless of hearsay or other evidentiary concerns. There has to be a base level showing of a conspiracy, and those statements may be entered against a defendant as if they were made by a defendant themselves. that has been long-standing Iowa law. It's been affirmed by the Iowa Supreme Court, as well as the rules of evidence. We're outside of the typical situation where one defendant attempts to assert the constitutional rights of another. Here, the unconstitutionally collected statements and evidence from Jeremy Goodale may be directly used by the state against Mr. Miller. That aggrieves him because there is now no one to assert those constitutional rights. Mr. Goodale has made it very clear he is not asserting those rights. And the case law that is cited by the state, and you will see very clear in their resistance, only has to do with the Fourth Amendment, Your Honor. Here, Iowa case law makes clear that we jealously guard our rights, our individual rights, under Article 1, Section 8. And under Article 1, Section 8 is where we assert Mr. Miller's constitutional right as an aggrieved party charged with conspiracy to suppress the unconstitutionally gathered evidence from Jeremy Goodale. I start with that, Your Honor, because our issues 3, 4, and 5 each are asserted under Rule of Criminal Procedure 2.12 in the language of that rule. Our third issue is a request to suppress the in-custody statements of Mr. Goodale, very similarly to our first issue, because as Mr. Miller, there was no arrest warrant for Mr. Goodale. As Mr. Miller, there was only a search warrant for DNA and fingernail scrapings. As Mr. Miller, the checkboxes that are required for non-testimonial evidence under Iowa Code Chapter 810 were not completed by law enforcement when they seized Mr. Goodale. And again, when Mr. Goodale was first confronted by law enforcement at his home, evidence technicians were there and could have taken all that evidence that was ordered by that search warrant. But instead, they took him to the law enforcement center, put him in a locked room. He made statements. That is an overbroad reliance on that search warrant that was not properly completed under Iowa Code. And again, we know the legislature has said that if you want to collect non-testimonial evidence, you have to use the procedures of Chapter 810. And if you don't, the Bozeman case from the Iowa Supreme Court in 2001 says that that evidence must get kicked out and that warrant is not valid. That's issue 3, Your Honor. Issue 4, suppression of Mr. Goodale's in-custody statements made under Iowa Code Chapter 232.11 because, again, when he was taken into custody, he was not afforded an attorney, and there was no waiver of attorney. As with Mr. Miller, Mr. Goodale is considered a juvenile under the eyes of this court and under the eyes of Iowa law regarding the conspiracy charge. He is also charged with conspiracy, a non-forcible felony, and murder, which is a forcible felony. Again, those statements made by Mr. Goodale while in custody in the law enforcement center are suppressed regarding that conspiracy charge, the non-enforceable felony, because Mr. Goodale is considered a juvenile in the eyes of the law under Iowa Code Chapter 232 regarding that conspiracy charge. And again, because those charges are viewed as different levels, that conspiracy charge, the statements have to be suppressed regarding those. Our 5th issue, Your Honor, suppression of the evidence that was collected from Jeremy Goodale's cell phone, his Snapchat account, his cell phone carrier. This is again asserted under, as Mr. Miller is aggrieved, an aggrieved individual under Iowa Rule of Criminal Procedure 2.12. These issues were previously addressed by this court and viewed by this court regarding Mr. Miller. However, this court has never viewed the search warrant applications and search warrants for Mr. Goodale. Those were not an issue at our prior hearing. The arguments are the same. Law enforcement did not properly provide information to the issuing magistrate. The search warrant applications had information that was inaccurate and incomplete and did not establish the required nexus of probable cause between the items to be searched, the places to be searched, and the knowledge of law enforcement. And because there is not probable cause for those search warrants to issue, and because Mr. Miller is able to assert those constitutional rights and point out to this court and ask this court to address the constitutional violations as an aggrieved person, the evidence collected there must be suppressed in any case against Mr. Miller. Your Honor, in speaking with the state, the parties, and I don't want to speak for the state, but it's my understanding that this court, we're asking this court to take judicial notice of the testimony, the prior exhibits and other evidence that was submitted in the prior suppression hearing, and also to take judicial notice of all the search warrant application files relating to Jeremy Goodale. There are two specific ones that are cited within our brief. However, we would ask the court to take judicial notice of all in the interest of completeness of consideration.
No objection, Your Honor.
And counsel, those search warrants, have they been made public yet? Or were those still sealed?
They were briefly made public, and I believe they're still under seal at the request of the defense.
That is my understanding, Your Honor.
So there's an agreement that I take judicial notice not only of this court file, prior evidence, but also any search warrant application involving co-defendant Goodale.
State does not object, Your Honor.
So I will take judicial notice of all of those things that I just listed.
Thank you, Your Honor. And we would request that those remain sealed. I believe the evidence that was submitted, not the testimony from the prior suppression hearing, but the evidence that was submitted was also placed under seal by this court. We would ask that any prior order sealing evidence or files remain.
Anything else regarding Mr. Goodale's search warrant with Mr. Goodale's cell phone?
Your Honor, the issues and arguments are very similar regarding our fifth issue here. I don't believe I need to repeat them. They're also very well documented in our motion and briefing. So I would stand on that regarding our fifth issue, which is Mr. Goodale's cell phone Snapchat account and the cell phone carrier information. Our final issue before the court, Your Honor, is a second request for a Franks hearing. And that request is made based on information and statements made or provided in the search warrant applications for Mr. Goodale. Those are, again, specifically cited within our briefing. If this court looks at the search warrant application, as this court knows, it provides an affidavit from a law enforcement officer of information known to that officer. What is now before this court and has not been before this court before is Mr. Goodale's applications. And looking at those applications, the paragraphs at issue, this court will likely recognize because they are nearly identical to those provided in the search warrant application files for Mr. Miller. And I say nearly identical because the glaring difference is that in Jeremy Goodale's search warrant applications and in the sworn affidavits in those applications, there is absolutely no mention that Willard Chaden Miller's name is anywhere within those Snapchat photos. As this court may recall, there were Snapchat photos that were shown to law enforcement, and law enforcement then said to an issuing magistrate that those Snapchat photos contained the name of Willard Miller. That's what was said in the search warrant applications regarding Mr. Miller. However, we now, looking at the search warrant applications for Jeremy Goodale, know that law enforcement knew Miller's name wasn't in those photos. How do we know that? Because we have a sworn statement from the exact same officer who wrote both sets of search warrant applications. In Jeremy Goodale's, it says Jeremy's name. This was Jeremy's Snapchat, and this is what he said. Information about an assault and a murder. We saw them in Snapchat photos. Your Honor, please grant us a search warrant so that we can investigate this crime. In Jeremy Goodale's applications, zero mention of Willard Chaden Miller. And we also know, in looking at all the evidence that was submitted in the prior hearing, that as soon as they wanted to get into Mr. Miller's phone, and as soon as they wanted to get into Mr. Miller's cell phone carrier account and Snapchat account, then they put his name in that search warrant application. Even though the sworn affidavit of the other one says nothing about it. This is evidence, additional evidence, of either reckless disregard for what law enforcement actually knew, or a purposeful misstatement to the end of violating Mr. Miller's constitutional rights in order to investigate a crime. Either way, this is new evidence that the court hasn't viewed, and this is additional evidence in the form of a sworn statement from a law enforcement officer. Two statements authored at the same time, provided to the same magistrate. Glaring difference. One includes Mr. Miller's name when they wanted to get into his personal possessions. The other excludes it because what they actually knew was his name wasn't anywhere within those Snapchat photos. Your Honor, we put to you that this is at least a preliminary showing when considered with all the other evidence of information that was incorrect within those warrant applications previously, to rise to the level of at least providing a Frank's hearing for a full review of what should have been in those warrant applications, what was actually known to law enforcement, versus what was given to that issuing magistrate. Just as one last thing, Your Honor, in the state's briefing, they had asked this court to admonish counsel for bringing the second Frank's application. I think our briefing and the facts before this court make very clear that these are 6 issues that are well supported by case law cited. And these are 6 issues that are well supported by both facts and a request by this court to protect the constitutional rights of Mr. Miller. I see these as legitimate issues, and I believe the briefing provides that as well. With that, Your Honor, we request suppression of the evidence we've identified. We request a full Frank's hearing, and presuming the state is going to provide argument, we also request the opportunity to respond. Thank you.
Thank you, Mr. Olson. Mr. Molding, on behalf of the state.
Thank you, Your Honor. We already addressed the preliminary matter of taking judicial notice of the prior evidence, testimony, briefing, and arguments in the suppression hearing previously. Procedurally, Your Honor, the motion by the defense does not need to be substantively addressed on its merits by the court today. The defense has already raised the vast majority of these issues to the court, and the court has already considered them and ruled on them, and denied each and every one of the 6 issues that were previously raised in the defense's motions to suppress and for an evidentiary Franks hearing. That motion, which was filed timely, some week or two after the filing of the arraignment, was exhaustively briefed. It was thoroughly argued, evidence was presented, argument was presented, and it was denied by this court. In fact, that ruling, which the defense has filed an interlocutory appeal on, is still under consideration by the Supreme Court. That issue has not been settled. They're filing a second motion to suppress 470 days after the arraignment and 39 days before trial, so far outside of the scope of Rule 2.11, which requires the filing of all substantive briefing 40 days after arraignment unless there's due cause, presumes that the rule essentially doesn't exist. I'm not one to typically stand on Rule 2.11 as the state. I recognize that, often things come up from a defense perspective, whether it's depositions, whether it's discovery. Sometimes things happen. I would posit to the court, however, that there is nothing in defense counsel's 40 pages of briefing on this issue that gives rise to an issue that they could not have addressed in their initial argument before the court. Judicial economy requires that we settle these matters and we take these matters to trial. We don't file our suppression issues one by one by one by one. Additionally, there are no material grounds for relief that are presented by defense counsel that have either not been addressed by this court previously or that defense has a constitutional or statutory right to raise. So I think that the court could address everything in defense counsel's recent argument and motion summarily without any detailed analysis by the court. However, in addressing the specific claims raised, first off, with regards to the claim that Miller was subjected to a, quote, illegal seizure by the police, this court knows that there's no requirement for an arrest warrant to be issued for a defendant to be arrested on first-degree murder. Miller was woken up by the police early in the morning of November 4th during the execution of a search warrant on his home. That warrant called for a search of his home, search of other items, including his phone and other devices, collection of physical samples from the defendant's person to include DNA, fingernails, and fingerprints. Defense counsel argues that the interview with Mr. Miller at the Law Center constituted an arrest. Well, Mr. Miller was asked to come down to the Law Center to speak with the police. He was afforded juvenile Miranda that was signed off by his mother, signed off by him, and he voluntarily spoke with the police. There was never an instance where Chade Miller attempted to leave or attempted to cut off conversation. Additionally, I don't even think the court needs to get into this, but with regard to taking him to the Law Center for the collection of physical materials, DNA, that can be collected via a vocal swab. Fingerprints, as this court knows, this court orders people to be fingerprinted all the time, are all done at the Law Center. People are fingerprinted on a machine in booking at the chair. There's no requirement for any additional material as to the Claim 1. Regarding Claim 2, this court has already ruled that the statements of the defendant are admissible. Defense counsel's argument seems to belie or ignore or gloss over the fact that Mr. Miller executed a valid juvenile waiver that was signed off by him and signed off by his mother. This was not a non-Miranda interview. So with regard to Count 2, which the state concedes is not a forcible felony, it is conspiracy to commit a forcible felony. Now, I guess I'll address the fact that Count 2, the conspiracy to commit a forcible felony, in conjunction with Count 1, first-degree murder, it made sense when the defendant Mr. Goodale were jointly charged on a single trial information with the murder of Mrs. Graver. We have bandied about the prospect of essentially trying this matter as scheduled, starting on April 21st, only on the count one. Because frankly, Defendant Miller is guilty on count one. His sentence is life with the possibility of parole. The count two conspiracy, the 10-year sentence on a Class C felony, would merge with a murder in the first degree, very likely. It's a substantial possibility. Additionally, well, it's clear what Mr. Miller is doing at this point is essentially trying to get a second bite of the apple on suppressing all the evidence that he was unable to suppress with his first motion. And since the time that this matter was filed jointly with count one murder, count two conspiracy, the case against Mr. Miller and Mr. Goodale has been severed. They were to be tried separately. And subsequently, Mr. Goodale has turned state's evidence and is listed as a named witness against Mr. Miller. So it is possible that the conspiracy charge would require some review. But the matter before this court is did Chayton Miller premeditatedly kill Noema Graver? The issue of the conspiracy with Jeremy Goodale is essentially a moot point. With regards to 3, 4, and 5, this is very simple. Defense counsel is trying to assert the constitutional rights of Jeremy Goodale in order to prevent testimony and statements being entered in the case against Chayton. I understand that the defendant feels aggrieved by the weight of the evidence against him. That doesn't give him an argument constitutionally or otherwise to challenge the collection of evidence against a third party. Chayton Miller can't assert Jeremy Goodale's constitutional rights, whether he's a co-defendant or a named witness or a third party on the street. There is no grounds to assert another party's constitutional rights. And that is black letter case law. That is very clear and very simple. I can't assert anybody else's rights constitutionally under the Fourth Amendment, under the Fifth Amendment, neither can anybody else in this room. The motions by the defense very clearly ignore the Fourth Amendment issues and weigh heavily on Article 1, Section 8 of the Iowa Constitution. Judge, Iowa law is clear on this, but defense counsel is setting up, what appears to this counselor, that they're setting up an argument on appeal to have the Supreme Court reconsider the state of the law as it exists today and find that there is a different constitutional standard under the Iowa Constitution than case law currently exists. Certainly well within the right to do so. However, this court's purview is to determine whether the facts as exist today and the law as exists today grant defense's remedies. They do not. Furthermore, with regards to count 5, they're trying to suppress search warrants executed on Mr. Goodale's devices and for his home. And this kind of bleeds into their argument for Claim 6. Law enforcement, through interviews of associates with the defendants, developed information, essentially that Jeremy Goodale confessed and admitted to killing Mrs. Graver. That is the thrust of those Snapchat communications and the interviews with Juvenile JB, as was previously heard in our first suppression hearing. So I'm going to a review of the State versus Grand case, just taking a step back. The Grand case was cited by the defense, and they made some arguments why it shouldn't apply. It's still the law of the state and the law of the land. They did a good analysis in that case that when analyzing the defendant's fruit of a poison tree argument, not everybody is entitled to complain about the quality of that fruit. Chayton Miller is not allowed to complain about the quality of the evidence developed during the investigation of Mr. Goodale. It's just simply not a right that he has. again, the strategy of the defense here is not entirely clear because the evidence that was developed from Mr. Goodale is likely going to be offered in this case through Mr. Goodale himself, through his testimony. Mr. Goodale, did you make any statements to law enforcement while you were at the law enforcement center? Well, that's not something that the defense can really suppress or object to. That is the statement of Mr. Goodale. It's his rights, it's his constitutional issue to raise or waive. Regarding the Franks plan, I really do believe that there's been an overreach by the defense on this. This issue has already been asserted, it's already been addressed, and it's already been found by this court that there was no material misstatements or lies or omissions by the affine officer. Seems to me that the thrust of defense's assertion that the police were lying in their sworn affidavits to the judge and magistrate in this case, is that the search warrant affidavit for Mr. Goodale stated Mr. Goodale in Snapchat and otherwise communications with others admitted to killing Mrs. Gregory. And with regard to the affidavit for Mr. Miller, it also includes that the statements from Mr. Goodale attributed partaking in that murder to Mr. Miller. There's no reason to put the fact that there is another defendant in the affidavit for Mr. Goodale's search. Mr. Goodale, police had records of Snapchats and testimony from an individual or individuals that had a conversation with Goodale of him admitting to killing him. The affidavit speaks the same. It basically states, during an investigation, Mr. Goodale admitted to killing Mrs. Gregory. That warrant stands on itself. The warrant for Mr. Miller also goes into detail about the assertions and statements attributed to, or actions attributed to Miller by Goodale. But there's no reason to have the additional information about a co-defendant in Mr. Goodale's search warrant application. The fact is that defense counsel is essentially stating because the two warrant affidavits are not verbatim identical, that there must be some kind of false swearing or lies or misstatements on the part of the law enforcement. Doesn't withstand scrutiny, Your Honor. There are two different affidavits because there are two different locations to be searched. The search for Goodale's residence named Goodale. The search of Miller's residence named Goodale and Miller because the information about Miller came through Goodale. Defendants already made all these arguments, most of them. He didn't get the answer that they liked by this court, but his remedy is an appeal, which is already going on. The Franks remedy is an extraordinary one, and it's said that extraordinary claims require extraordinary evidence. The structure of our criminal justice system relies on sworn attestations by law enforcement, truthful attestations, and there's just nothing that defense can really point to here to suggest that law enforcement intentionally and fraudulently attempted to deceive the issuing magistrate on these affidavits. This has been thoroughly briefed, and this court found that while there was a misattribution of a statement of Miller to a Snapchat record, when in actuality it was testimony from the witnesses that were having this conversation, amounts to an innocent mistake and a misattribution, but certainly not a fraudulent deception on the part of the police. These have all been these issues have already been settled, and I think that if the court doesn't find that this matter is due for summary addressment, that each and every one of the issues raised by defense counsel are either already raised judicata by this court or do not constitute claims that defense counsel has the right to assert. Thank you.
Go ahead, Ms. Arnstein.
Thank you, Your Honor. Just to start with the last thing addressed by the state, the affidavits support the prior testimony and the prior evidence, which shows the Snapchats provided to the affiant only address Mr. Goodale. There is an assumption by an informant that another person would have been Mr. Miller. There is not any evidence that there was some Snapchat that directly implicated Mr. Miller. Not having that in front of the issuing magistrate is exactly the lack of evidence that we are talking about and the reason that we're requesting a Frank's hearing. But I'm going to step back and address the first thing that the state brought up, which was 2.11. Your Honor, I believe 2.11 really sets out time limitations when you're talking about speedy trial and protecting speedy trial. In this case, there are a few different things that come into play. One, the state had all the information that we are talking about here, but there has been a development that is newer, which is that Mr. Goodale has gone from co-defendant to witness. And that changes some of these assertions. Instead of waiting for Mr. Goodale to assert some of these protections, it now falls upon Mr. Miller. Additionally, the court's prior ruling really brought to light that there was a difference in the way that the court would treat a forcible felony and a non-forcible felony. So this is taking that next step, and our motion was filed very shortly after the prior ruling. Your Honor, I think the court can also look at judicial efficiency. If this is deemed an error, that just sets us up to address this issue again. So there are a number of different things that would address any concerns under 2.11. I also think that the record will show, and Your Honor, I don't know exactly where, that at some point the state had made some statement that that they had waived timelines for motions. I don't know that any deadline was put on that. But these are distinct issues. They are supported by case law as set out by Mr. Olson in argument. They are supported by evidence as shown by the prior testimony and the admitted attachments within, and Your Honor, I believe the court did indicate it would consider all the submitted evidence by both parties. Is that correct?
Correct.
So now the question is really, have there been new assertions and new information? And Your Honor, I think that's well set out. There is a difference between the Miranda claim and the claim under the Fourth Amendment. I think the state referenced Graham, and I don't know that Graham applies to a Fourth Amendment challenge when there's a non-conspiracy, when the charge is not a conspiracy charge. Your Honor, and again, we look at the affidavits as supporting the Franks claim with all the information that has been put forward, but the addition of those affidavits showing the differences and recognizing that the additional language that was added is specifically incorrect. It refers to Snapchat that didn't say what the affidavit says they did. Looking at all of that, Your Honor, we would assert that these claims are supported and that they do rise to the level of a constitutional violation for Mr. Miller. And Your Honor, even if there was not initially an arrest and the state gets the presumption after a certain point of holding Mr. Miller, it rises to the level of an arrest without warrant. Certainly, as was stated, there was no need to remove him from his home in order to collect evidence. I think the state indicated, well, this is where we usually do fingerprints. That may be where they're usually done, but it isn't where they have to be done. Technicians have the ability to collect fingerprints, fingernail swabs, and DNA samples without issuing an arrest and without the coercive nature of putting someone into a police cruiser, isolating them from parents, isolating them from other people, and holding him where he is unable to leave. Certainly, I think there is certainly evidence establishing arrest. Your Honor, I will not go into each of the different issues. They are all set out in the motion, which has been briefed. So we don't need additional time for briefing. It is set out in the brief that was provided to the board and within the evidence that's before this court.
Thank you, Ms. Branstad. Further record on this issue, Mr. Mullen or Mr. Brown?
Nothing substantive, Your Honor.
And as far as record goes, for today's purposes, what further record do we need to make on behalf of the state?
I think that the record's been made, Your Honor.
And on behalf of the defendants?
We don't have anything further for the record, Your Honor.
Okay, well, I'll deem the new arguments, filings submitted. I'll take judicial notice of the court file, which I believe I've previously done. Also, previous evidence submitted in this case file, along with the search warrants issued, or Mr. Goodale is the subject of a search warrant. And is there anything else that counsel is requesting and consider other than that?
I believe it's clear, Your Honor, that the court has taken notice of all the testimony provided at the first suppression hearing.
Correct.
Your Honor, and the related exhibits and attachments.
Yes.
Nothing further on behalf of the defense.
Okay. I'll deem the matters submitted and get a ruling out as quick as I can. Thank you.
Do you need us for anything else today?
Yeah. When you guys get a chance to come back,
Okay, we're gonna do it back in chambers.
talk logistics.
Okay.
overview there. I was thinking your camera should go up there.
Yeah, right. You got a much better view. Doesn't look like there's a
Is
door.
there a door on this back side?
Doesn't look like it.
Could be a trap door in the floor.
Oh, yeah. I wonder why they built that like that.
Huh. I wonder if this is a remodeled room and maybe there had been a balcony area, but they decided to maintain a little bit of the history by putting